Hi, in this immigration law update video, I want to look at a new case from the Court of Appeal, which is very important. It's called EWCA Uddin, and it's 2020 EWCA Civ 338, and it's a decision from the 12th of March 2020. And Sir Ernest Ryder, the senior president of Tribunals, gives the judgment, and he allows the appeal against a decision of Deputy Upper Tribunal Judge Manuel, who had upheld a decision of first-tier tribunal judge Hurley, who had dismissed the appellant's human rights appeal. Now, just some background facts. The appellant was is a Bangladeshi national. He was born in 1999, so he's now 20 years old. And he was found abandoned in 2013 in London, treated as a trafficked child and placed into foster care. Now, he claimed asylum, and his asylum claim was rejected, but he was given leave as an unaccompanied asylum-seeking child. At the end of that period, a further leave application was made, and that was refused by the Secretary of State. The appellant appealed to the first-tier tribunal on Article 3 and Article 8 grounds, and it's fair to say the first-tier tribunal focused on Article 3. And the first-tier tribunal dismissed his appeal, focusing on that Article 3 element, finding his historical narrative not credible. Now, one thing the Court of Appeal noticed is that nobody in the first-tier tribunal or the upper tribunal properly analysed the evidence in respect of Article 8 and the relationship the appellant had with his foster family. And there was evidence from the appellant, his foster mother, and the local authority, which was uncontested. Look at paragraphs 7 and 8 of the Court of Appeal's judgment. Now, when the Court of Appeal analysed the judgments of the first-tier tribunal and the upper tribunal, they noticed that the first-tier tribunal, as I've said, found the appellant not credible in his historical narrative. See paragraph 10. And the first-tier tribunal judge had used that to impact the applicant's overall credibility. Now, the Court of Appeal give an important reminder at paragraph 11, and I'm going to read it to you. Forgive me for reading it, but it's important and it'll become obvious as I read it. It says this: I note in that regard the conventional warning which judges give themselves that a person may be untruthful about one matter, brackets in this case his history, without necessarily being untruthful about another, in this case the existence of family life with the foster mother's family, known as a Lucas direction, and the citation is given there. The classic formulation of the principle is said to be this: if a court concludes that a witness has lied about one matter, it does not follow that he has lied about everything. A witness may lie for many reasons, for example, out of shame, humiliation, misplaced loyalty, panic, fear, distress, confusion, and emotional pressure. That is because a person's motives may be different as respects different questions. The warning is not to be found in the judgment before the court. This is perhaps a useful opportunity to emphasise that the utility of the self-direction is of general application and not limited to family and criminal cases. So there's that important reminder from the Court of Appeal here that just because somebody may lie about one aspect doesn't mean they're lying about another. And that's something that as practitioners you might want to remind a judge about when making submissions, where you've got an appeal that has, say, an asylum element and an Article 8 element. And that may be also something that could be useful in using when drafting grounds of appeal. So the Court of Appeal go on to say that the first-tier tribunal found that Article 8 wasn't engaged, and the first-tier tribunal had relied on the Kugarthas judgment, which concerns adult Article 8 relationships. Now, in respect of the upper tribunal, the Court of Appeal noticed at paragraph 14 that the upper tribunal's analysis of Article 8 is concise. Now, there's nothing wrong with being concise. They say that's a skill, but they do note that the Deputy Upper Tribunal Judge had not analysed the evidence in respect of the Article 8 relationship. And by the time the case was in the Upper Tribunal, the only issue was Article 8. The Deputy Upper Tribunal judge was also critical of the judge who granted permission to appeal to the Upper Tribunal and said it was a generous grant of permission, but the Court of Appeal make note of that and say they disagree. There's another paragraph that is important and of general application. I'll read it to you. It's paragraph 15. It says this: the deputy judge also held that the FTT's determination was carefully prepared by a very experienced judge who made a meticulous and balanced assessment of the evidence in the round. I entirely concur with the import of his observation insofar as it recognises that tribunal judges are specialist judges who are expected to know the expert materials in their field, such that an appellate court should have appropriate regard for that specialist experience. That is quite different from an implication that there is a factor to be considered in an appeal that experienced judges should not be expected to make a mistake. In commenting that it, in inverted commas, would have been an elementary and unlikely error for any judge in a jurisdiction which revolves around Article 8 issues, he was applying an assumption which is an inappropriate approach to an appeal. So yes, it's right to respect first-tier tribunal judges as specialist judges, but we don't make the assumption that they've taken into account all relevant factors. So that's, again, an important paragraph which you might want to rely on, particularly in grounds or when challenging a case before the upper tribunal. Now, the deputy upper tribunal judge in this case introduced the element that foster carers are appointed by a local authority and it's a commercial relationship. And for this reason, he found the judge was entitled to find there was no family life, dependency hadn't been established, and relying on the judge's general findings on credibility. The Court of Appeal found that the Deputy Upper Tribunal judge was regrettably wrong, paragraph 17. In the Court of Appeal, the Secretary of State had argued that foster carers were in a special relationship which was different to other Article 8 relationships. So the Court of Appeal analysed the case from paragraph 24 on. And what they say at paragraph 24 is, look, there was no proper analysis of the evidence on the existence of family life and dependency. Therefore, the case must be set aside. Then they go on to consider this idea, are foster carers in a different relationship? They analyse the judgment in Cougarthus and they focus on what's said by Lord Justice Sedley. And the Court of Appeal say at paragraph 31, again, a really important paragraph, dependency in the Cougarthus sense is accordingly not a term of art. It is a question of fact, a matter of substance, not form. The irreducible minimum of what family life implies remains that which Lord Justice Sedley described as being whether support is real or effective or committed. So they find that the question of dependency is a factual one. There's no need for exceptional dependency, and that foster carers are not in a special category, and there's no support for that proposition in the case law. See paragraph 34. They finally look at whether reaching adulthood has a significant factor, and they say, paragraph 36, the existence of family life after a young person has achieved his or her majority is a question of fact. There is no presumption, either positive or negative. For the purposes of Article 8, continued cohabitation will be a highly material factor to be taken into account, and while not determinative, a young adult still cohabiting with a family beyond the attainment of majority is likely to be indicative of the continued bonds of effective, real or committed support that underpin a family life. And it's still sometimes an assumption of the Secretary of State or the Tribunal that once majority is reached, family life is automatically extinguished. Well, this is wrong. There is no positive or negative presumption. We look at the continued facts. So finally, the senior president summarises at paragraph 40, the test for the establishment of Article 8 family life in the Cougarthus sense is one of effective, real or committed support. There is no requirement to prove exceptional dependency. So that's going to be generally helpful to you when dealing with adult Article 8 cases. Secondly, the test for family life within the foster care context is no different to that of birth families. The Court or Tribunal looks to the substance of the relationship, and no significant determinative weight is to be given to the formal commerciality of a foster arrangement. It is simply a factual question to be considered, if relevant, alongside all others. So that's helpful, particularly when you're dealing with unaccompanied asylum-seeking children who've built up a family life with their foster carers. And thirdly, the continued existence of family life after the attainment of majority is also a relevant question of fact. No negative inference should be drawn from the mere fact of the attainment of majority, while continuing cohabitation after adulthood will be suggestive of ongoing real, effective or committed support, which is the hallmark of a family life. So that's important where you've got somebody who's become an adult and you're still trying to show family life. So this, on first blush, you may think this case is just to do with foster relationships in Article 8, but there's so much more in this case in terms of the approach to Article 8 and adults, in terms to the approach of errors of law, and to the approach of credibility. I hope that's helpful to you.